All right, so this session is about copyright and trademark. So if you were taking a craft session, this is not it. So we're going to start. I'm going to leave time for questions at the end, but feel free to raise your hand if you would like to during the session, and I'll try to get to you then as well. But I'd like to get through all the slides if possible. So this is copyright and trademark, what every author needs to know. This is all the legal disclaimer language that I put in all my presentations now. I am an attorney. This is not legal advice. This is information at a conference. I'm not necessarily your attorney. You have to sign an engagement letter to be represented by an attorney. If you're in here and you're my client, this is not my advice to you necessarily, because I would have an individual conversation with you. So this is about me. It should say USA Today best-selling author in front of that, and I think I might be up to 25 or 26. I have a pen name as well. It gives you a little bit of background as to who I am. My law practice kind of grew up around me because all my writing friends figured out that I understood contracts. I was a subsidiary rights agent at ICM, which is now being purchased by CAA. So I worked specifically in books to film, representing authors, and then also worked with screenplay writers and directors. And one of the things I'm really proud of is I was a co-founder of the Women's Fiction Group. So what is copyright? So copyright is a legal device that provides the creator of a work of art, literature, or a work that conveys information or ideas the right to convey how the work is used. So copyright, the intention of it is to have protections for artists so that artists can also receive revenue streams. The founders had a lot of foresight with this. They understood that in a democracy, having ideas, new ideas that people could learn from was really important. But they also understood that people creating those ideas should be able to make some money from it so that they could live and continue to create. So art, literature, those are important foundations as to our democracy. So why copyright? So the main goal of copyright is to encourage the creation of new intellectual and artistic works. So this is your book, and this is a magical place for all authors, right? And I like to use this slide specifically because I like to think of a book as a seed. It's this thing that you spend all your time and energy creating, and from that one book, this amazing giant tree flows. And what I want you to think about is that every one of those branches is a subsidiary or derivative or ancillary right? So the book is the primary underlying piece of intellectual property. And what springs up is something that you can then exploit all these ancillary rights from. What rights does the copyright give you, the author? It gives you reproduction rights, distribution rights, the right to create adaptations, aka derivative works, and performance and display rights. And those are yours. And you get to determine what you do with them. You get to determine if you exploit them. You get to determine if you sell or license them. Again, my picture of my tree. Because every branch is a different kind of right that comes from that one seed. How long does a copyright last? A long time. So I'm going to work under the assumption that all the things that we're talking about today were created after 1977. And if you own the copyright for something that predates that, you can see me because there's all kinds of different. I have a cheat sheet on my desk. It's a little bit different if it's pre-1977, but if it's 1977 and since, it's the life of the author plus 70 years. And that's also why estate planning is so important to authors, especially independent authors who have bodies of work now that are reaching hundreds of titles, because you can pass that on to your heirs and they can receive remuneration for 70 years after your death. Works for hire are 95 years from the date of publication or 120 years from the date of creation, whichever comes first. So, an author's copyright may only be exploited or exercised by the author or a person or entity the author has licensed, transferred, or sold all or part of their copyright to. I like to speak to independent authors about beginning to think about your intellectual property as actual property. right? Every title that you write, every title that you create is part of your intellectual property portfolio. And it can be managed in a very similar way as you would manage real estate, like if you owned a bunch of rental properties. Because every book has several revenue streams, and you own and control all of those, and you need to be, and I talk about this in my licensing talk a little bit later today, the idea that you want to begin to think about how can I exploit every book to its fullest potential so that I'm squeezing revenue from all of those possible subsidiary and ancillary rights. So your underlying copyright grants you that. So how is copyright created? Copyright is automatic. You don't have to file, you don't have to do anything, you just have to write a couple words on a page and you've got your copyright. A copyright comes into existence the moment an author or creator fixes his or her words into a tangible form. You guys are really savvy, so you probably already knew that. A number of authors don't know that. They think that you absolutely have to file to have a copyright, and you absolutely do not. When you file for copyright, it grants you some additional rights as well as protections, which I'm going to go over. Common copyright misconceptions. A work must be registered with the U.S. Copyright Office to be protected by copyright. No, absolutely not. You're protected by copyright. Again, you get some extra protections, and it does shift the burden of proof away from you if you're the owner of the copyright, if you've registered it. Only works that have the copyright symbol on them are protected by copyright. I hear this a lot from authors, and it's absolutely untrue. No, copyright is automatic. No one can use a protected work without the copyright owner's permission. Again, false. This has never been true. You can use protected works as long as they fall within the bounds of fair use. Fair use is a defense. It's not something, I would not argue that you should rely on it, especially with certain specific materials. Fair use is a little bit convoluted sometimes. I'll go over it later on in this presentation. And fair use generally, it's hard to make it apply unless it's a transformative work, a satire, or if it's for educational purposes. So for your fiction that you're going to make money off of, it's hard for you to rely on fair use as a defense. You can copyright a great idea. No. Copyright only protects the expression of an idea, not the idea itself. This is why we don't see individuals copywriting tropes. You can't copyright a trope because it's your writer voice. It's your expression of whatever you're writing that makes it unique to yourself that allows you to have the copyright for the work. While copyright is automatic, best practices are: put a valid copyright notice on all published works. I'm sure all of you indie authors do that already, right? You put it either in the beginning or the back of your books. Register your work with the U.S. Copyright Office after publication. Within 5 months is optimal. Why register with the U.S. Copyright Office? In case of infringement, right? There are infringers out there. We've all seen them. I'm sure we've all sent takedown notices. Some of us may even have companies that do that for us. They sometimes listen, they sometimes don't. Registered copyright, what it does is it shifts the burden of proof to the infringer as to ownership, right? Like if you have filed for the copyright and somebody infringes and you decide to sue them, you no longer have to prove that you were the person that actually wrote the work because the copyright is in your name. Now the infringer, it's their burden of proof to somehow prove that they were the ones who generated the work first. So, makes the author eligible for statutory damages. It also makes you eligible for attorney's fees. I am not a litigator. I was a long time ago. I no longer litigate. This can be really important. I have a client who went through this not too long ago where she had not filed for copyright on her work and she discovered that it was being infringed upon. And she had a really tough time finding an attorney that would take her case. And the reason is that right now it's $50,000 to $75,000 to walk into a courtroom, right, and sue somebody. And this is a real challenge, I think, with independent authors because through the traditional publishing route, if a traditional publisher discovered that a work was being infringed upon, they would use one of their army of attorneys that they kept in-house to take care of that. And now as an indie author, you have to kind of bear the burden, you have to bear the burden of that cost on your own. So that's a bit of a challenge. And she was able to find someone, but it was a really expensive endeavor on her part, and she actually had to stop the pursuit of it because she really just couldn't afford to move forward with it. So I would encourage you to file for copyright because it does allow for an attorney to say if they win, they're going to get attorney's fees. What is copyright infringement? Copyright infringement occurs when a person other than the copyright owner exploits one or more of the copyright owner's exclusive rights without the copyright owner's permission. It's not just copying your work, right? We've all seen those pirate sites that put works up. It's also, say you had a title and suddenly you looked on one of the audiobook distributors and someone had actually created an audio work of your title. That's copyright infringement as well. Because if we go back to the picture of the tree, every one of those branches is a way to exploit your underlying intellectual property, and so infringement could be in any one of those areas, since it all stems from that original intellectual property. What to do if someone infringes on your copyright? Right? I could have put a pirate up there too, right? Send a cease and desist letter to the infringer. If you can find them. That's one of the challenges, isn't it? What does that do? It puts the infringer on notice that you're aware of what they're doing and you intend to come out after them, whether you intend to or not. It establishes a date for your discovery of the infringement, which could become important in a court case. It tells as far as damages, right, your monetary award, it can help to determine that. It tells the infringer you intend to stop them. So before I get into how to file for copyright, I want to tell you that you don't have to hire someone like me to send a cease and desist. You can send a cease and desist on your own. Oftentimes people hire me because those three letters after my name, ESQ, they feel have a lot of weight, right? And they can get more of a reaction from someone, which may or may not be true. A cease and desist, if you send it to an individual that you believe is infringing upon your copyright, it needs to say the titles, it needs to say where you saw it, it needs to say the date that you saw it, it needs to say that explicitly you're infringing on my copyright, take this down. If you don't, I'll proceed, with legal action. So it's to put them on notice, and you absolutely can do that on your own and save yourself some money. I'm happy to do it for you, but you can do it on your own. So how do I file for copyright? Here you go. This is another area where I think that an independent author can make a decision as to whether or not they want to pay someone like me to do it. Our firm does a lot of these. There are a lot of authors who say, they just want to farm that out. They want somebody else to do it. And we're happy to do it on your behalf. It costs a lot more money if the firm does it instead of you. I think right now it's about $65 at the Copyright Office to file for copyright. The website itself is pretty self-explanatory. It's a little time-consuming, but not too terrible. I mean, if you sat down with a bunch of them and did them on a Sunday afternoon, you could get through it. Once you've done 2 or 3 of them, you'll never forget how. So I would say it's a great way to save some money, but you are utilizing your time, which is invaluable. The difference between trademark and copyright is that trademark protects expression of a good or service in the marketplace, and copyright protects all creative expressions except for slogans, names, titles, short phrases, which is the very things protected by trademark. So the thing that is interesting, and I think I want to differentiate a little bit between it, is that a copyright protects the creator of the underlying intellectual property, and it protects their ability to exploit their works. Trademark, in a lot of ways, while it is an asset, it's a brand asset, and I'll talk a little bit about that. Trademark is there also to inform the buyer in the public what they're getting. So if you have an imprint in the marketplace, it's a way for you to kind of have your imprint and have the market be aware that it's you and not someone else who's using a similar sounding name or a similar looking logo. So one is more inward facing, in my opinion, and one is more outward facing. So trademark. What is a trademark and why would I want one? So under both federal and state laws, a manufacturer, merchant, or group associated with a product or service can obtain protection for a word, phrase, logo, or other symbols used to distinguish the product or service to others. So trademark offers protection to brand assets. And I want to give you some examples of brand assets, then I'm going to go through how it applies to independent authors. Because here's the thing, you guys are entrepreneurs and business people, and some of you are building 7, 8-figure brands. And that's really important that you understand that your brand assets have value on top of the words that you write. So I used this yesterday, and I think it really informs us. So there's only really, 3 things that have letters up there, and yet we all know what they sell and what they mean. And arguably, these pictures, some of them are possibly one of the most valuable parts of these individual brands. And think about the marketing money, the advertisements, all of that has allowed these images to now be in your brain and you know exactly what they mean. So a pen name is a brand asset. You can trademark a pen name. You can't, I would argue that you want to trademark a pen name once you've kind of established yourself in the marketplace. You know, a lot of people create multiple pen names, and I don't know that you want to do a intent to use on a pen name. I think that you really want to wait till there's value there, because to trademark something is time consuming and it's not cost prohibitive, but it can be expensive. It can be pricey. So, but if you have a pen name that you're really making a lot of money over or you intend to use for the rest of your life, I mean, like Nancy Drew is trademarked, Dr. Seuss is trademarked, Theodora Taylor is trademarked. So there are individuals that like to trademark their pen name, and that's so that in the marketplace, nobody else can start using that one or one that sounds like it. That's why. A book series name. You cannot trademark a title, which you guys probably already know, but you can trademark a book series. This is usually more successful if you have 3 to 4 books. Anything less than that, the USPTO may come back with an action saying, we're not sure. But if you have 3 to 4 books, so if you have a long-running series and you're concerned that somebody else is going to try to edge into that name, you may want to consider trademarking it. How do you register for a trademark? Trademark search. So one of the things that we do as a firm, and this is what you would have to do if you do it yourself, because you do not have to be a licensed attorney to trademark, unless you come from, unless you are a resident of a foreign country. If you're a resident of a foreign country and you want to trademark in the U.S., they do want you to use a U.S.-based attorney. And since it's federal law, you can use an attorney anywhere in the country. You're not relegated to using an attorney that's only for your state, because it's federal. Same with copyright. So the first thing that you or me or whoever has to do is you have to do a search to see if there's anybody else using that term that you want to use, whether it's the pen name, whether it's the series title, whether it's the logo. You have to do a search. And that's because if you do a search, if you don't do a search and you file, and you get an office action back from the USPTO saying someone else is using this, not only have you put the other party on notice that you're infringing on their trademark, but you've now just wasted a whole lot of money that you spent to file for trademark. So we do the search first. And then we write an opinion letter, and the opinion letter is meant to, here, this is the visual of it. The opinion letter is after we look at the worldwide search of are there any, let's just take an example. So Theodora Taylor has trademarked her pen name. Do a worldwide search, and we look to see, is there anybody else using this for ebooks, for audiobook? Are they doing T. Taylor? Are they doing Theodora Taylor? You do multiple spellings, you do all of that. You search for everything. So there's multiple classes in trademark, and you may, in your search, find that there is a Theodora Taylor who sells steaks in Nebraska. That's really not going to be problematic, because the Theodora Taylor that has trademarked her pen name is only going to be selling books and audiobooks. So the USPTO is going to say, fine, no problem, there's not going to be any cause of confusion there. The market is going to understand that the person selling steaks is not necessarily the person selling books. So we'll let that go. But you still have to assess all of that, right? So you assess all of that, and then we write an opinion letter, and it's just like green light, yellow light, red light. The red light is if I get a ping on the search that says, oh my goodness, there is a Theodora Taylor who is selling comic books. I might say to her, I don't think you're going to get this through the USPTO. I think there's going to be an action for confusion. I don't think they're going to give it to you. Now then it becomes the determination of the author as to whether or not they want to proceed, because we're all grown-ups and we get to make those decisions ourselves. But my advice would be that you're not necessarily going to get it through. It's going to be too close. The yellow light is if there's something that could be a little bit similar, right? Like if there was a Todd Taylor selling audiobooks, we might get some sort of action and we might have to respond to it. But arguably we can get around that with a response to the USPTO. So again, it will ultimately be determined by what the author wants to do, whether or not they want to proceed. And the green light is me saying, this is yours, and I really do not think you're going to have any problems with the USPTO when you file. Proceed to application. So the Trademark Electronic Application System, it's a little bit more challenging than the copyright system. The information needed for application. The owner of the mark. These all seem like they make a lot of sense, right? Owner of the mark, name and address for correspondence, depictions of the mark, goods and services, the class with which you are going to try to get your trademark filed into, the application filing fee, the specimen for application, and a signature. So the specimen for application is really your mark out in the wild, right? So the USPTO wants to see what the buying public is seeing. So we often use a lot of screenshots, and the screenshots have, say if we're doing a pen name, we're doing a screenshot of the social media for that author, and you always want to have the date that you took the screenshot because the USPTO wants to know that. And you also want to put the URL where you found it, and I'm going to tell you why. So after you file for trademark, you pick your trademark categories. So I think I wrote this down because I always use a little thing on my desk that talks about the specific categories that would be interesting to you. Okay, so there are 45 trademark classes. And usually for indie authors, it's number 9 for ebooks and audiobooks, and 16 is for book series and printed books. So those are the 2 classes that we generally file for. There could be additional ones if there's something else. I have, a couple of authors who also have classes. So I think that's under 41, if I'm remembering correctly, something like that. So you pick your classes and you file, and the thing is that the other thing that you can do as an author is you can get on the USPTO and you can look up other registrations and filings, and you can actually see how they did it. It's all up there for you to view, and that's really an interesting thing to do. You file the application with the USPTO and you pay your filing fee. And then you wait. You wait a long time. So one of the reasons that we do all of those things on the front end is that everything that you or I as an attorney have done before filing the international search, the trying to see if there's somebody else out there who uses the same trademark, now the USPTO is going to do it on their end. They're going to do the exact same thing. Well, I've never been an examining attorney, but they do something similar, right? So once you turn in your application, right now it's taking about 3 months to get an examining attorney assigned to each application at the USPTO. Once you get that assignment, they will do their international search. They will look at the specimens. They will review and determine whether or not your or my opinion as to this individual should get the trademark on this matter. They will let us know if they agree or disagree. We always hope they agree because it takes less time, and then you just kind of sail through. So these are the things that they will do. They will either issue an office action or you will proceed to publication. The dreaded office action. The office action comes back when the examining attorney for the USPTO has a concern that there is a mark that's too similar, or they don't understand what it's about, or they don't think that this individual or this entity really has made an imprint on the marketplace, and therefore, why would they have a trademark? So an office action. Now this is where you get into a situation where If you receive an office action back, I would never say that you can't respond on your own, but what I am going to say is that I think that at this point you may want to hire someone like me, because the office action is kind of leading up to the appeal section if you would ever want to fight it, like if they come back and they say, no, we're still going to deny it. So this becomes more legalese, right? Like what we're doing is we're arguing law at this point, and we're using the facts of what you have to try to convince the examiner that they should let this proceed to the Gazette and then be a registered trademark. You have 6 months. The likelihood of confusion office action. That comes back when you've filed for a trademark and the examiner is saying someone in that same class, say audiobooks, has too similar a name. It doesn't have to be identical. It can just sound similar. It can just look similar. But because they have a similar name, the buyers in the market will confuse that trademark with the one you're trying to file. And since the other person already has the trademark, you don't get to get yours. So a lot of times it's really educating the examiner how there's a differentiation between those two individuals or those two entities, those two logos, those two brands. It's the production of more specimens. It's an explicit legal argument. It's an argument to them with facts and also law to try to persuade them to see it differently. You respond to the office action, you have 6 months to do so. From the date that the office action comes back to you, you have 6 months to respond. So once you get past that, you then proceed to the Gazette. And that is where they will publish your trademark. It used to be an actual little paper Gazette. It's now, I don't know if they still do a paper one, but it's now also on their website. And at that point, the rest of the world has 30 days to object to the filing of the trademark. So it's to give notice to anyone out there that might think that they have a trademark or they have a claim to this trademark that you're trying to register. And then you wait. I can say that right now it's taking between 9 to, well, during the pandemic it was longer. I mean, I would say 12 to 18 months. 9 is a solid sort of, you've kind of breezed through, but it takes a long time to get trademark. And it also is variable on, I've noticed, whether or not they have a lot of examiners at the USPTO or if they're looking for new attorneys. If they're looking for new attorneys, sometimes there's a backlog and it takes a while to get all of these things back. The other thing is that the examining attorneys oftentimes will reach out directly instead of going necessarily through the USPTO interface, especially if they have a kind of a minor sort of change that they think is necessary or they have a small question. There are occasions when I'll get an email from an examining attorney saying, if you will change these 3 words in the description, we'll just go right through. And usually I say, oh yeah, I can do that, or that will work, and then it just goes right through. And I'm never quite sure why. Like every examining attorney is a little bit different in how they look at different applications. It's interesting, I participate in a group of attorneys who file and register a lot of trademarks, and we have a lot of conversations about how the examining attorneys determine what is gonna kind of like ping them at any given time. And it feels like they might have a session like this and they talk about the things that they need to be aware of, and then all of a sudden you're getting all these office actions on this one area that you weren't receiving any office actions on before. So once you go through the registration process and once you have gone through the Gazette and you've had 30 days and nobody has objected, then you receive a certificate of registration. They're very fancy, they look really nice. Some of my clients frame them. You know, I always like it when they get those. And now you're a registered trademark owner. So yeah. So I think I still have a lot of time for questions, and I'm happy to take them. I often get a lot of questions about copyright and trademark, and also the different subsidiary and ancillary rights and how you can work with those. So, and then, oh yes, we do have, one of my friends said, you need to tell people that you do. Yeah, we do trademark. And then this is my information. If you ever have any questions or I can be helpful to you in any way, feel free to reach out. So, and then yes, questions. Yes, sir.
It seems to me that copyright protects you from the risk somebody else snatching that trademark, that logo, that
Mhm.
letter, and getting it faster to market. You don't have any protection until it's been used out in the world.
Well, trademark has to have been used, definitely, but I can say that what can happen is that there are people that not necessarily haven't applied for the trademark, but if they find out that someone else is filing for the trademark, that they will then enter in an objection, and they can use the fact that they were usually using the trademark out in the world prior to that, even though they haven't filed for it. But yeah, so copyright happens the minute you put pen to paper. Trademark, you have to proactively file for it. And it doesn't just affix, although you do have some arguments if you were using it before someone files for trademark. Yeah. Yes?
On copyright, once you've filed the copyright on a book you've written, if you go back to that book and do some editing, some minor wordsmithing, all of that, you're not going to call it the next edition. You decided it's not that, call it an edition. Do you have to file a new copyright to get the statutory protections?
I get this question a lot. So the question is that you filed for copyright once, you go back and you do some minor changes, do you need to file for copyright again? It really does depend on how much the work has changed. I would argue that not necessarily do you have to file for copyright again if it's minor edits. But if you add additional matter, if you add additional chapters, if you do anything that changes it substantively, then I think the protections, you would be better served if you file for that. Yes?
If you have books that are older than that 5 months and you never had previously filed for copyright, how is that addressed legally?
Yeah.
Can you still do it later after 5 months, or is it too late?
So the question is that if you have books that you haven't filed for copyright within that 5-month sort of window, should you still file? You absolutely should still file. There are definitely some protections that come into play if you do it within that 5-month window, but you are not precluded from other protections that are there by not doing it within that time period. You will have kind of this area that, if the infringement sort of started in that time period where you hadn't filed, then there's going to be arguments in court, as to all of that, whether the burden does shift or doesn't shift. But I am a big believer in the safety of filing for copyright, so I would advocate that you do so. Yeah. Yes?
This may be a really dumb question, but if somebody is not using a pen name and
Yeah.
they're using their regular name to write, do you want to put that out there? Because what if somebody else is writing under your name, but that's your actual name?
You know what? You can't really trademark your own name. Yeah. I mean, it's actually a lot tougher to trademark your own name than it is to trademark a pen name. And there's a really famous case with regards to that. There was an author who tried to trademark their original name. Wait, I shouldn't say that you can't. I should say that it's harder and there are more hurdles, right? A pen name is actually easier. Now, when you trademark an author pen name, there are 2 additional documents that the trademark office wants to see from the author with regards to that. And it's basically that you're utilizing it and you're controlling that pen name. And then the second one is that it is your pen name and that you're authorizing it to be filed. So these are really short documents, but they'll send you an office action to get those 2 documents from you. Yeah. Yes? Mm-hmm.
Do you do under both names, or do you do under one? And then what do you do if you guys split? Who gets to own?
Those are great questions. So are you saying that you have one pen name, but each of you write under that pen name? Okay, that was the first question. The second question is, what happens if the 2 of you split? Who owns the trademark? Well, the trademark is an asset. It's a piece of property, right? It's something that you own. So I would say that if there are 2 people writing under that pen name, you're both going to have to be participatory in I take that back. As co-authors, you could determine who owns the pen name, right? And you could also determine through an agreement who has control over filing for those sort of legal documents. You could also put the pen name in a corporate entity, like an LLC or a corporation, and you could say they own that entity owns the pen name, right? Most likely what's going to happen is that the two of you are going to have to file together, and you're going to need dual documents that say that you're allowing for that pen name to be utilized. Now, this goes back to some of the things I was talking about yesterday as well, is that co-authors, I really encourage you as a co-author to the two of you, if you're both here or wherever, sit down, have a Zoom, write down how you intend to interact with each other now in good times, so that if things ever go south, you've already written down how you intend to handle that. So if you were to split, one of you could sell the right to the trademark to each other. You could convey it to a corporate entity or an LLC that would then own it. You could one could license it for use to the other, meaning that your co-author could say, I will license this pen name to you. You can use it for whatever you want, but you're going to pay me a percentage of whatever revenue comes in under that pen name. I feel like those conversations are easier had when people still like each other. Copyrights are property as well. That's why I think there's such important brand assets, because we're business people and entrepreneurs, and lining all of that up. It also helps later on with regards to estates. I mean, you might want to sort out in your agreement between the two of you who is meant to participate in that trademark or copyright if something tragic happens to one of you. How is that going to be handled? Because now you're dealing with somebody's heirs who may or may not be privy to the conversations that you had. So it's, I mentioned yesterday I'm going through this with a new client where he and a co-creator had created this really fabulous piece of intellectual property. They were best friends, and now they don't speak to each other. They never papered it. And so they're trying to figure out, like, how are they they can't even talk to each other. Are they gonna license it? Is one gonna buy it? How are they gonna do that? And they're having to go through attorneys. And that gets more expensive. Yeah, of course, yes. Oh, okay.
Very good. So I'm just wondering, on behalf of some of the authors here that have had, deals with publishing companies, so I know that like our company will file for copyright on behalf of the author. Now say a company does that, and so like they've filed for copyright, they've done all this stuff, and say that company gets sold, right? And so now all of the documents, all this stuff goes off to another entity. Like say like you worked with Tantor and they're owned by Recorded Books, and Recorded Books now has all that stuff, and you don't know how to reach out to them to get your stuff back. Like you don't. Is there a legal way to reach out to that company and say, hey, you have my mastered files, you have my documents, you have my edited documents, all this other stuff, and I need to get that back.
Yeah. So there's a couple of things, and since I'm not going to repeat it since you used the microphone and it would have been picked up, and it's a long question. So here's the thing: is that the first thing I want to ask is that in this hypothetical that the hypothetical that you've provided, did the author sell their copyright, or did they license? They license it, and did they do it for the life of the copyright? Right. And is the copyright filed in the author's name? It should. Yeah. Right. So, well, you can actually go to the U.S. Copyright Office, and if the copyright has been filed and you type in the author's name, it'll pull up. So you can check it online to check that. As far as the other elements of that question, this is a question that I try really hard in the agreements to make it very specific, that if a company is sold or assigned or anything like that, that the author gets written notice, because it becomes a chain of title issue. And it becomes a chain of title issue for all kinds of subsidiary rights, not just audio, not just comic book, but film and TV, right? And that's the big ticket item that everybody wants. And so you have to be able to show chain of title. I would say that probably what you're going to do is that whatever company purchased the smaller well, first of all, if it was for a term, when those rights revert back to you, as long as it's explicit within the agreement, then those rights are yours. If it's Tantor, I don't know. It will also depend whether or not, is the hypothesis that the Tantor files are meant to come back to the author, the audio files? Because that's an outlier agreement if that's the case.
Right. So yes. Right. So say, but it's like someone else now has physical control of the files, right? And so thank you. So say you have a deal with them where you are supposed to get the mastered files back at the end of your deal,
Right.
And now a new company, and obviously Tantor and Recorded Books are lovely and wonderful companies.
Right. It was just an example.
Just an example.
Absolutely.
Right. So say they have your mastered files and this company is sold. How and they have physical ownership of those files and you do not. How do you get to them?
Yeah, so you're going to have to reach out to their business affairs for that company, and you're going to have to, and this is also really important as to why you want to keep your contracts and agreements, because if you keep your contracts and agreements, you can send that with the letter. So you're going to want to reach out to whoever the business affairs is at that company, and you're going to say, this is the agreement, the term has expired, in the agreement I'm supposed to get the files back, please send them. And hopefully they do what you asked. Right, that is the thing, but sometimes I'm going through a thing right now with a client where somebody is infringing upon the audio copyright, and they're just ignoring me. And so and so the thing is that I think one of the challenges, again, it goes back to this idea as an independent author, the value, does she want me to find her a litigator that's going to sue this person for one audiobook? Probably not. Whereas if it was Random House, they might use one of their army of litigators to walk into a courtroom and file to get somebody's attention. So that's a little bit challenging, I think, for us as indies. Yes? Oh, sorry, yes.
So this just piggybacks on my question about the trademark. So if I'm writing under my legal name, and somebody trademarks that name as a pen name.
Oh, I see. That was the question. I'm so sorry. You would want to file. Well, you would file an objection. You would file an objection.
But how do you know? So if they come back and go, hey, stop using that name because I trademarked.
Do you know someone who's using your name?
No. I'm just saying.
Right.
In the future, you go like, hey, that's my legal name.
Right. So you would want to. So if you see an author who's using your pen name, then you would want to say, "This is my name," right? And you might even want to check periodically to see if they're filing for a trademark for it. Once it registers, I haven't done any post-registration objections, so I'm not sure. It gets into an area of law that I don't do. It becomes more litigation because you're in front of the trademark board at that point. So, yes.
How much does it cost to file a trademark?
Yeah, so and it changes. So I want to say in my head there's one that is TEAS plus and one that is TEAS, and I want to say one is $275 and one is $325 per class. I like the more expensive one because if something shifts or changes, it allows you to modify. Whereas if you use the cheaper one and you have to modify, you have to pay an additional fee, and I think it's $125. I'm not an accountant for a reason, so I might be flipping those numbers, but it's on the USPTO website. So as a firm, what we do is we're more expensive than that, but we do all of the laid work, including the search and the opinion letter and all of that. So, yes.
What if somebody wants to place, you're getting a business loan, somebody wants to place a lien against your copyrights?
Ooh. I've never had to do that. So a lien against your copyrights, I'm going to play this out as though I know what I'm talking about, but I don't. So I think that since it's copyright is a piece of property, they're going to file a lien against it the same way you would like a house.
Yeah, to use it as collateral.
Yeah, for that. Yeah. And then they're going to have to remove, is it USS 7? I think, and then once you have paid that off, they're going to have to proactively remove it. But it's going to preclude you from conveying those copyrights in any way. It may even preclude you from licensing them. But I don't think it will preclude you from exploiting some of the derivative works. But again, I've never had to.
Continue to be used
Yeah.
in order to be valuable to them.
Right.
So
I've never dealt with that. Isn't that funny? That's the first time I've even gotten that question.
it's a really odd situation.
Yeah. That's interesting, though, to me. It's something new. I like new things.
How do they value them then?
Well, there are people that will do that. They will hire an attorney, a literary estate manager, someone like that, and they will look for valuations in the marketplace. They may also ask to see sort of the earnings over a period of time, I'm guessing that they're going to evaluate them the same way you would value anything else. Like, you know how when you want a bank loan, they send somebody out to look at the property and then they have knowledge of comps? So, yeah. Yes, Judith.
So, a publisher license rights
Mhm.
for a particular term, changes the cover and edits the content, the original content.
Mm-hmm.
At the end of the term, the rights that revert to the author, are they the original script and the original cover?
Depends. It depends on the agreement that the publisher has. So me as generally I'm a representative of authors. I like that. I don't love this whole sort of we edited it so we own our edits. I do understand that it's a different perspective from the publisher than it is from the author. But here is the challenge with that, is that oftentimes edits are not so substantial. It's hard to kind of pull those things apart. The cover, it really depends on the agreement, the way it was set up. You know, some publishing agreements will allow for authors to buy their covers at the end of the term. It'll be explicit in the agreement. And so I think that as an author and as a publisher, as long as you're explicit as to how you want to handle it, right, then make a deal. Yeah.
Okay, I'm bogarting a second question here, and it's a two-parter, okay? So if I were, I'm not going to do this, but if I were to do the worldwide search for a copyright, or for a trademark, I would assume that Google is
It's not enough.
It's not enough. So where do I find a list of the resources that would say this is enough? So that's part one.
Right.
And then part two is, it would seem to me that before I go and create a logo or a series name,
Yeah.
that I would want to do that
100%.
first. Okay, so,
100%.
Okay.
I have clients that do that. And a lot of big corporations, before they do a new brand or a new rollout, they will do exactly that. They want to do the search first. Yeah, so the other thing is that you would want to get on the Trademark website because they have a place where you can search what has been filed, right? What's been registered. You'll do a Google search, and then there are different companies. One of them is Markify, which we use as a resource to kind of help us with our search. So we do a number of searches, and then we compile all the information. I can tell you that it feels like to me that really it's the analysis of those searches that is the value of what an entertainment or a trademark attorney brings to you. So, Markify. Mm-hmm. Yes.
This is totally a new question. Do I need to copyright every single book in the series or one book?
Every book in the series is an individual entity. Yes.
If you did not copyright your first book,
Uh-huh.
rebranded it, so you made new cover, not really new content inside, do you need separate copyright or do you all move together?
File now for what you have. How far apart did you publish them?
3 years.
So you technically have a copyright on the first one because you wrote the first one. You could file for that. Did you add a lot of new elements or did you just rebrand it? Which one do you think you'll have more sales with? Now I'm getting into this pragmatic, practical sort of conversation, not necessarily legal. So I would file for copyright now. I would keep your records from the last one. I'm guessing that, and again, can't give you legal advice, but playing it out, 99.9, you're going to be fine with that. But do you know, I mean, so here's the thing, and this is the thing about Trademark too, is that no matter how much we search, no matter how hard we try, it really comes down to decreasing risk. I can't ever say to a client, 100% this is going to go through, 100% it's going to file, 100% it's going to save. This is why people hate attorneys. Because they pay us a lot of money and we can't say, this is it. But we can try to decrease the likelihood of somebody coming after you. Yes, sir.
Just to follow up to that, so what if you do have a series and you are rebranding it, it's going to be significantly different content within the book, different cover, different everything, and it's been about 10 years?
Oh, wow. Did you file for the first one? So file for those, do the change, file again. Especially if you're going to change the content. Because really, in some ways, you could say it's transformative, that it's completely different.
Is that the same case if the title's the same?
Oh, that's a good question. I don't know. I'd have to look that up. Do you want me to If you email me, I'll try to find that out. I want to say that you would, like in my mind, the little ping is do them both, have them both for safety. But if the title's the same, you may run into an issue with the.
Would we care to reach out on LinkedIn?
Yeah, or just email me. Yeah. Yeah. Yes.
Question on transformative in terms of copyright. For cover designs, we license photos, Shutterstock and all those kind of things. If you have like Frankenstein, the human being,
Oh, let me tell you, we're out of time, so if you guys need to go, you can, but I'm happy to take your question. Do you want to? Sure. Yeah? Thank you. Thank you so much. Yeah, thank you.